safe protection. I will always be around. Will it ever get sunny? Oh, I wonder, honey. I'm tired of being in the line. You say it will. I'm caught in your addicted brain. You say it will, yeah. I'm causing the obsessive line. You say it will. I'm caught in your addicted brain. You say it will, yeah. I'm causing the obsessive line.
Hey everyone, welcome to a special episode of Trucksafe Live, the monthly show where we and our guests tackle the hot button issues impacting highway transportation. I'm Brandon with Trucksafe Consulting and Childress Law, both of which are dedicated to helping motor carriers develop and maintain cutting-edge safety programs. Like I said, special show today, some breaking news in the industry. Yesterday, within the last 24 hours, June 30th of 2022, if you're watching later, news out of the U.S. Supreme Court that they are denying review. They have denied review in the CTA versus Bonta case, which is the California AB5 case. This has gotten a lot of attention in the industry over the last couple of years. We've been watching it pretty closely over that time and waiting on the Supreme Court to issue its decision on whether it's going to even hear the case or not. So that's what we're going to talk about in today's show. It's, like I said, breaking news with the potential to have big impacts, at least to fleets that have operations in California. So that's what we wanted to tackle today. Just briefly, wanted to kind of run through the procedural history of the case for those who aren't as familiar with the case. So in 2019, state of California passes what was called Assembly Bill 5 or AB5, which essentially codifies the ABC test for worker classification determinations in the state. Individuals who are classified as independent contractors, whether or not that person is an independent contractor, is going to be determined based on this ABC test, which we'll get into detail later. That's AB5 essentially. For the reasons we'll discuss in a little bit, that test is kind of the thorn in the side of every trucking company that utilizes independent contractors, making it nearly impossible to use independent contractors in California. California Trucking Association sued to enjoin California, the state, from enforcing that test against trucking companies, arguing that that law is preempted by a federal law known as the Federal Aviation Administration Authorization Act, F4A, sometimes called, or F-Quad A, in the sense that the argument by CTA was that California's AB5 is a law related to the price, route, or service of motor carriers. That's kind of the standard used by F4A as to whether it's going to preempt a state law or not. CTA got a federal district court in California to agree, at least in the preliminary stages, granted an injunction in 2020 prohibiting California from enforcing AB5. The state then appealed that to the Ninth Circuit Court of Appeals in California, which sided with the state and held that AB5 is not preempted because it's a generally applicable labor law, not a law specifically targeted at a motor carrier's rates, routes, or services. So that happened, and then the CTA from that point sought discretionary review from the U.S. Supreme Court. And as we've talked about in prior shows, the U.S. Supreme Court, except in very narrow circumstances, is not under obligation to take appeals that are brought to its attention. It has the discretion to decide under the certiorari process what cases it wants to take up. It's generally going to take up very few cases that get brought to its attention. I think the numbers are like less than 1% or something like that, crazy. So very rare for them to take up a case. They typically only take up the cases in very specific circumstances. Those that are generally going to have a big impact on a big portion of the country, generally speaking, are the cases they're going to take up. And so we have been in this kind of limbo phase where we've been waiting for the Supreme Court to decide whether it was going to take up this CTA case or not, and that's where that's where the decision we got yesterday. SCOTUS denies review, which is going to have, like I said earlier, pretty wide implications across the industry. So that's the topic of today's discussion. Wanted to bring on a guest with us today who is intimately familiar with this topic. So I would like to welcome on Doug Grawe. So Doug is CEO of Grawe Group, LLC, a law and professional consulting firm focused on the transportation industry. Doug has more than 15 years of experience as a general counsel at a large family-owned truckload, intermodal logistics, and warehouse provider, and more than 10 years in private practice. He's also currently general counsel for OpenForce, a technology-driven business service providing industry-leading services to independent contractors and motor carriers, including driver onboarding, settlement processing, and many other solutions. Welcome, Doug.
Thanks, Brandon. I really appreciate it. Thanks for having me on. Happy to help.
Appreciate you being here with us, and couldn't think of anybody better to have on with all of your work that you've done over the years on the independent contractor reclassification issue specifically. For those of you who are here watching, if you haven't seen our past show, we have had Doug on a few months ago along with Wendy Greenland from OpenForce. We did a whole show on independent contractor classification best practices. Go back and check that out if you missed it. It's on our various social media channels and on our YouTube channel and at trucksafelive.com. But Doug is here with us today to talk about this case. So Doug, let's kick things off here. Just tell us, give us a general sense of your involvement in the IC issues over the years.
Yeah, so I was very fortunate early in my career with my big in-house client that I had for many years, and some of the mentorships I got early on. The family that owned my original client, and I can say the Oren family, they very much believe in being involved. They believe in being engaged in the industry with your trade associations and so on. So they encouraged me early on to get involved. So that was just great to have that backing, that support, and so I did. So I got involved in some of the lobbying that's gone on over the years on independent contractor status. I got involved in, it's a good sized company and they had their own shares of matters over the years. So I got some experience through that as well. But they also had an attorney there. He has since passed on, but his name is Jim Hardman. Jim Hardman really was one of the lions of the industry. Started out in the 1950s. His very first case went to a state Supreme Court when he got out of law school. And I remember that he could write articles only citing himself. Just a prolific writer on all things independent contractor. He got me into it. So I've published a handful of articles over the years about independent contractors. But more specifically on this case, a couple of trade associations and clients reached out to me and asked me to write briefs to the U.S. Supreme Court, encouraging the court to do this. So I was able to team up with another very good lawyer, Mike Glover. Mike and I worked together to put together what I thought were some pretty good briefs, kind of explaining why trucking companies use independent contractors, why independent contractors like being independent, just to kind of give that background to the court so they knew there's real people that are impacted by this decision. Unfortunately, it didn't go our way. but it wasn't for lack of trying. The industry definitely was engaged on this issue. That's for sure.
Yeah, so let's get right into that case. So the case is CTA versus Bonta. I kind of gave the brief procedural history at the start, but can you give us a better feel for kind of the primary issues involved in that case?
Yeah. So there is some heady constitutional law kind of stuff. Does the federal law preempt states from being able to enforce laws that impact the services that trucking companies can provide? That's really the issue. Does federal safety regulations, do federal regulations and economic regulations related to trucking companies prevent states from enforcing laws that impact the services trucking companies can provide? Unfortunately, the Ninth Circuit Court of Appeals said no, they don't, not in this context. And the U.S. Supreme Court, it's not like the U.S. Supreme Court said we're endorsing the Ninth Circuit's decision and they absolutely nailed it. I used the sports analogy. The officials in the booth said, we're not going to take a look at that. We're not saying we agree with it. We're just saying we're not going to take a look at it. So it stands. That's really what happened.
Yeah, so interesting. You mentioned Ninth Circuit, and as I understand it, one of the reasons we had more hope than normal of potentially getting to the Supreme Court was because we've got what's called a circuit split on the issue. We've got some circuit courts of appeals that agree with California. Then we've got other circuits. I think First Circuit maybe has come out with a decision that says there is preemption in this type of arena. Is that true?
Yes, that is. So to a little bit more context for folks. So in the judicial world, in the court world, the country is broken up into circuits. Okay. And each circuit represents a handful of states. And like you said, when the circuits disagree, when they get the same issue or very similar issues, and one circuit starts saying the law means, applies this way, and another circuit starts saying the law applies another way, that's when the Supreme Court does like to get involved to say, hey, children, you're not doing this right. This is the way the rule should be applied. And that really is kind of what it is. So we thought as an industry that there was a clear line of cases coming out of the First Circuit. So that's some East Coast states with the Ninth Circuit, largely the West Coast states. Okay. And we said, hey, the First Circuit, we thought as an industry, applied the rule correctly, and we thought the Ninth Circuit didn't. We thought it was pretty clear. Now, I don't want to bore people with too much of the wonky details. It wasn't quite as clean as I'm making it sound. When the court decided not to take this case, they didn't write out a long opinion explaining why they didn't. They just didn't. And it's one line says denied. So we can only really speculate why they didn't. I think one of the reasons they may not have is there's still some facts that needed to be flushed out more. And what I mean by that is one of the arguments that the industry makes is, hey, this rule in California is so arduous, so painful, so strict, whatever adjective you want to use, we can't really meet it. There's no practical way to meet it. If I'm an opponent of the trucking industry, I could make an argument that there was not enough facts in the record to make that claim. I'm an industry person, so I think that's a bogus argument. But I could see the court basically thinking to themselves, you know what, honestly, there's too much mud here. It's not clean enough for us to make a decision. So one of the things that might still happen, now I'm in the kind of the inner sphere of this. I am not one of the attorneys that is representing California Trucking Association. I am not their attorney. I know who those attorneys are. They're very good attorneys. They're doing an excellent job, but they will decide whether or not they're going to continue to fight this. There actually are more things that they can do, but it's going to take a lot more money and a lot more time. And while the lawyers try to figure out all those nuances of arguments, what our listeners need to understand right now is California can start enforcing any day now. I think technically it's 7 days, so sometime next week they can start enforcing this.
Yeah, and I forgot to mention this at the start. Anybody watching live, if you got any questions or comments about the issue, throw them in the comment box, and we'll get to them as we go here. Doug, you had mentioned something interesting. It's something that you don't see very often in our industry, but vast support, it seemed like, for the Supreme Court to take up this issue, including against what we often see as traditional foes, like the American Trucking Associations and OIDA, the Owner Operator Independent Driver Association. We're kind of on the same page here that we think California has done something wrong here and that the Supreme Court should step in and clarify. Why is that the case? Why is this the issue where we see vast support in the industry for essentially what the district court did in joining the application of AB5 and then to try and get that up to the Supreme Court?
Yeah, great point. And I think the reason you see that that unification, that alignment, is all industries. Trucking is not special in this regard, but all businesses sometimes can get in the habit of, oh, the sky is falling. This is going to be the worst thing that's ever happened to us and all this kind of stuff. And after a while, if you're a politician or a judge or anything like that, you get a little bit tired of that argument. I'm not going to say truly the sky is falling, but it was pretty clear early on when this legislation was being considered, much less passed. It's not hyperbole to say this could significantly impact the whole industry, not just California. We can all badmouth California all we want, and I can get on both sides of that. There's some really good things about California too, but I think
Like
the
the weather.
stats say it's the weather and everything, but it's, I think, the fifth largest economy in the world. So you kind of have to deal with it.
Yeah.
It's pretty tough to say we're just not gonna worry about the fifth, sixth largest economy in the world. So I think you saw the alignment because there was a significant chance, or a huge chance, this was going to have a significant outcome on all parts of the industry. Couple that with owner-operator business model has been around literally for over 100 years. Okay, and it's not this. I think there's this myth out there that trucking and transportation just uses independent contractors, and we just abuse independent contractors and all that kind of stuff. Well, depending on whose stats you want to look at, there are somewhere in the 3 to 4 million professional drivers out there. Okay, there are a few 100,000 independent contractors. I don't think I've seen an estimate that's as high as 1 million. I think the estimates that I usually see are in that 3, 4. I've seen as high as 600,000. Okay, so it's a big part of the industry, but it's not all of the industry. I say that to mean is it's big enough that everybody cares about, but it's not the only thing, which to me means we can all get on board with drivers should have choices, trucking companies should have choices. In California is taking away one of those choices, probably.
Yeah. I guess we should back up and talk about AB5 more specifically, just so for folks who aren't as intimately familiar with it, what exactly does AB5 do, and why is it such a potential game changer now that it's going to go into effect?
So AB5 that's the legislation name. It was, when it was passed, it was Assembly Bill 5. That's why it's called AB5. It is what it does, it puts into play what's called the ABC test. Now, it only puts the ABC test into play for certain types of claims in California. It's not for everything. It's not for taxes. For example, it's not for work comp, but it is for some wage and hour stuff. So the ABC test is used in a variety of states. It is not just used in California. So we all need to make sure we understand that, first of all. But California's version of the ABC test is worse than other areas. And it's the B prong. It's an ABC test because it's a 3-factor test. You can call it the 1, 2, 3 test if you want to. It's 3 factors. The middle factor, the second factor, says to be independent, the worker must be engaged in work that is outside of the contracting company's business. So if you are a trucking company, it is difficult to say that a truck driver is not engaged in the same business that you as a trucking company are. Now, your software engineer that you might use to work on a project for you, that's pretty easy to say. I'm not a software company, I'm a trucking company, so the engineer's in a different business. But California's strict interpretation of you must be engaged in a separate business, that is difficult to meet because trucking has something that no other industry has. And I'm speaking specifically when you get over 26,000 pounds here. Truth in leasing regulations. When you start talking about truth in leasing regulations, and Brandon, this is very near and dear to your world. We're talking safety here, okay? And for very good safety reasons, we can argue about whether or not the law is correct, but I can understand the spirit of it. 90 years ago, the federal government said, whether you call them independent contractors or employees, we are going to hold you, trucking company, responsible for any accidents they cause. Okay, that's in common terms, we call that logo liability. That's why you got to have your DOT, your name and your DOT number on the side of the truck. Okay, well, that rule that makes carriers responsible for motor vehicle accidents also says the truck must be exclusive to the trucking company. So if I've got the mighty U.S. federal government telling me that I must maintain exclusive control over this truck, and I've got, and I don't say this in a belittling way, that California, big state, influential state, saying I cannot have exclusive control over this truck, that is a really tough nut to crack.
Because essentially what the federal leasing regulations are intended to do, at least this was kind of their primary intention, as I understand it, was to create this legal fiction. So traditionally under the law, the contracting entity that contracts with an independent contractor, most laws in every state will recognize that the contracting entity isn't going to be liable for any conduct of the independent contractor because the independent contractor is independent. They're responsible for their conduct. But what we were having was some, probably not a lot, it probably wasn't widespread, but people were wise to this idea. And so they were structuring their businesses so that we consider these drivers to be independent contractors so that when they go get involved in an accident, we can push it off on them and minimize our own exposure. Well, we didn't want that in the trucking company, an inherently dangerous company. We wanted the parties that have the deep pockets and that have the insurance coverage to be on the hook. And so what we did through the federal leasing regulations was create this legal fiction where even though these are independent contractors in every other sense, we're going to say that they are under exclusive lease to the motor carrier, and through that legal fiction, that legal fiction that is the lease, it's not a traditional lease agreement, but we're going to call it a lease so that we can create this situation where the motor carrier takes on primary responsibility, highway accident exposure for any accidents that those contractors are involved in. Is that generally speaking how
well
it
said?
works? Okay.
Very, very, very well described, and it leads to this whole. There's always a little bit of friction in any trucking company that uses independent contractors. Of I got safety issues I got to deal with, and I've got independent contractor status and how to respect freedoms and all that kind of stuff. And we're not going to go too far down that path in this discussion. I can tell you, you can do it. You can be a good, safe trucking company that uses independent contractors. And I would argue a lot of data suggests that they are very good when they use independent contractors. Independent contractors tend to be pretty safe. But you're exactly right that the federal government essentially said, we don't want arguments about independent contractor status to impact safety.
Yeah. So it was never intended, as I understand it, though, to say anything about the economic relationship between the two. In other words, the federal government very explicitly, they say this in the regulation, we're not weighing in on whether these are your employees or not. What they should have said, frankly, is that these are not your employees But regardless, put that aside. They say we're not weighing in on it. We're only doing this for very specific reasons. And so over the years, we've used that language in the federal leasing regulations to point to the fact that clearly, just because they're leased onto you as the motor carrier, that's the government is saying that has no impact on their employment classification. But unfortunately, that just hasn't carried the day in a lot of these states, especially California. And so there are some states that buy into that, and other states that don't. And so that kind of leaves us, where we're at currently. So you kind of got into this a little bit. In what I'm curious, what areas is AB5 is the ABC test that is now going to be the law of the land in California, and what areas of the law is that going to impact, at least for carriers with operations in California?
Yeah, most specifically, directly, it's going to be in your wage and hour issue. So if you stand the risk of a misclassification claim related to minimum wage, overtime, meal and rest breaks, that kind of claim, the ABC test will be used. And California gets even more complicated than just the ABC test, because if I'm on the other side of this, let's pretend for a moment that I can't stand independent contractors and I hate trucking and all that kind of stuff. I'm going to say, well, trucking, it's not as bad as you think, because even if you can't meet the ABC test, there's this business to business exception, and you can meet the business to business exemption. That's gobbledygook. I don't want to say here you cannot use independent contractors in California. I'm not on this call here. We're not being anybody's individual attorney. It's always a case-by-case analysis. There are ways you probably can still structure something, but that business-to-business exemption is not an easy standard to meet.
It's multiple factors, right?
Yes, and so let me back up and make sure we walk through this for a moment. If you have a lawsuit that is on your desk tomorrow that says we're all independent contractors in California and we're suing you because we think you've misclassified us, the first thing that any judge is going to look at is they're going to say is, do you meet the ABC test? If you do meet it, you win. There you go. We're done. If you
have to meet all prongs, right? You have to meet
all three
prong.
prongs.
Yeah.
Yes. And we just established why that would be very difficult for a trucking company to meet. So let's assume for a moment you cannot meet all three or don't meet all three. Then what's going to happen is you are going to go into, do you meet the business to business exemption, which is going to use another, is it 10 factors, 12 factors? It's a lot of factors. Borello test, which you also must meet all of the factors. It's not a majority, it's all of the factors. And it's difficult for trucking companies to meet this second set of factors, because it's going to say things like, does the independent contractor advertise their services to the public? Well, it just doesn't make a lot of sense in trucking to have a Google ad for an owner-operator when their carrier's giving them all the business they need or want. And, oh, by the way, we just talked about all this truth in leasing regulations and the difficulty of working with multiple carriers at once and all that kind of stuff. They're in this 12 factor, whatever it is, secondary test. There are a number of those that just don't make practical sense in trucking, which makes it still very hard to meet.
It's almost like they didn't draft these laws with the trucking companies in mind.
Well, and I would say is they did draft them, and not to get too much into the politics of this, but I think we do need to understand some of the politics of AB5. Okay, there is a long history against it. This bill and this law didn't come up out of nowhere and get passed in a year. It took a long time for its proponents to get it passed, and its proponents are a variety of different groups. Yes, organized labor is one of the proponents. Environmental groups are some of the proponents. Community activists and community organizations are some of the proponents of this legislation. And now I'm not going to say trucking is the only industry they cared about and they targeted, but make no mistake about it, we were at the top of the list. And you can go back to clean air issues in and around the ports, and old trucks. That's really where a lot of this starts. And that starts, you're talking early 2000s when that stuff's happening. And the argument was, hey, our air is very polluted. And I don't actually discount this point. There are plenty of reports out there that the communities in and around the ports have significantly worse air quality, and there are health outcomes in those areas that are sad, honestly. The cause of those and who shares the blame for that, I think, is a different discussion. But the facts are there's some air issues there. So the argument went by the proponents that you trucking companies are using independent contractors, and these independent contractors are using old, dirty trucks. And you should be buying brand new trucks to run in these areas. Now, couple of different things there. First is there's the business aspect. We all know that when you get a brand new truck, you don't want to put that in local operation. You want to put that over the road, like let it get the miles. As it gets older and you need it to get maintained more, that's when you bring it closer to home. That's just good business. Okay, that's how to keep your eyes on that truck and get your money out of that investment. Okay, but that whole notion of the argument that trucking companies were being too cheap and using independent contractors to skirt getting new clean trucks in, that's the start of AB5. And that's who was in favor of publishing these rules. So that's why trucking is a target.
We saw even more brazen efforts at the start. I think of like the Port of LA case where essentially the ports came in and said, you're not allowed, if you're a trucking company coming in the ports, you can't use independent contractors. We're not even going to let you in. And I think that case did eventually get held to be that rule eventually did get held to be preempted. But so then they have come up with other ways to put the pressure on trucking companies, knowing they can't go quite that far. But what we're going to do is implement a test that's virtually impossible for the trucking industry to pass. And let's get back to that prong B. Why exactly is that so tough? At least because we've talked about the ABC test being in place in other states other than just California. Why is California's B prong of the ABC test so hard for the trucking industry to pass?
In other states, the B prong says that you do not, that the person can be independent if they are performing a service that is either different from what the contracting company's business is. Okay, that's the same as California. Or that it is performed outside of the offices or locations of the contracting company. Truck driving by its very nature is going to be outside of the physical locations of the contracting company. So that's why in other states the ABC test is usually something you can still meet because it's written differently. The California version is written more strictly, and if your business is, I am a trucking company, I have U.S. Department of Transportation authority to haul freight. That's what a motor carrier is. You haul freight. If you are using an independent contractor who hauls freight, it is difficult to argue you're in different businesses. I think you can make an argument. It is difficult to make a winning argument.
And there have been some courts in other states that have latched on to those arguments. I think of the one that always has been persuasive to me, at least, is if you look at what the services are being provided, right? So you look at owner-operators who are essentially providing truck capacity. Their customers are the motor carriers. Their customers aren't necessarily the shippers and the brokers. They are working they're selling their capacity in their trucks to the motor carriers, whereas the motor carriers are selling services to their shipper and broker customers. And we've seen some courts, I think, in the Midwest states that have latched onto that to help motor carriers prevail in these types of reclassification suits, but not California. It's not going to fly in California.
Yeah, you're right, and I think there's also some cases out there that I think rightfully recognize what a motor carrier does in this arrangement is, hey, we provide you access to bigger shippers, friendlier freight, that you independent contractor would not otherwise get access to. we help you get access because we can provide higher liability insurance levels. We can do the billing and the collections. We can do the sales work. We can do the data interchanges. We can do all that back office stuff and that risk management stuff so that you, independent contractor, can focus on, hey, how many trucks do I want to have? Who do I want to have driving my trucks? How do I want to make sure that I have a good fuel purchasing and fuel utilization strategy? Which, as an aside, I think we all know, recognize how, if you're good at that, you're going to be a good owner operator. You're going to make a lot of money. If you're not good at that, you're not going to make good money.
Yeah.
So don't tell me they're not business people. Those are big decisions. How new a truck are you going to get? And all those types of things.
And hiring your own employees and hiring your own drivers to work for you. So I think one of the most interesting things about this is who stands to benefit from AB5 going into effect in the trucking industry. Because I think a lot of proponents of AB5 will try and throw the wool over your eyes and say that it's going to be the drivers who are going to benefit from this, the folks who have been oppressed, they will say, and who have been misclassified as independent contractors. Granted, there's going to be some of those out there who they are oppressed and they should be reclassified. But in my experience, and I'm sure it's the same with you, Doug, and the vast majority of these, that's not the case. And so my question to you is, who really stands to benefit from from AB5 legislation?
Yeah, it's who you think it's going to be. Organized labor definitely stands a chance at benefiting from this, because when someone is an employee, not an independent contractor, they can be organized. And hey, I have no issues with people who want to organize being able to organize. That is their right. They should be able to do that. I think a lot of the surveys out there and a lot of the evidence suggests most, not all, most independent contractors enjoy being independent. And when forced to become employees or not have work, they're not going to choose to become employees. They're going to adjust and they're going to go someplace else and do something different. Some will become employees, but not all. And I should say, it's not just organized labor. I mean, you can make some arguments that there'll be some other tangential benefits here and there.
The big one I think of is the plaintiff's bar, right? Because especially in California, we have been for the last 10 years, as we talked about on our independent contractor show, this rash of cases where the plaintiff's bar has become wise to the ways to win on these reclassification suits on behalf of a class of drivers, and they just make bank doing those cases. And so now they've got some more leverage in the form of AB5 to prevail on those cases.
It definitely makes their job easier. There's a strong likelihood you don't have to worry that much about going to trial. It's a matter of your work is all in just collecting that class to start if you're a plaintiff's lawyer. So yes, they very much will benefit from this. Unless the industry changes the business model a lot, then you may prevent them from ever having the claim in the first place. But yes, you're right. They stand to gain, no doubt about it.
So that's one question I did have early on is whether the Supreme Court's decision to deny review here and AB5 going into effect. So it's not currently in effect, right? When will it go into effect? You mentioned 7 days or so.
Yeah. So the Ninth Circuit, when they made their decision, I may not use the terminology correctly because I'm not a constitutional law expert, but they stayed the case. They stayed their decision, which essentially what they said is, we're ruling against you, trucking industry, and we're ruling in favor of the state of California, but our ruling will not go into effect until the Supreme Court says something. We're going to give you an industry time to appeal this.
So that's left that injunction in place to this point.
Yes, that's left the injunction in place. Yes, that's the better word than stay. They left the injunction in place. So but their decision did say once the state or the Supreme Court speaks or doesn't speak, or chooses not to speak, then our ruling goes into effect. And it doesn't go into effect 6 months from now. It goes into effect. Now, this is where I'm not saying I 100% know this, but it is my understanding is I believe it is 7 days from the day the Supreme Court denied review that the Ninth Circuit's injunction or stay will be lifted. So regardless, we're not talking about months or years. We're talking about days, maybe a couple of weeks. And of note, this can be retroactive.
Yeah, I was going to ask you about
California
that.
can go backwards. This is not just, okay, we can go after you for whatever you're doing now. California can go backwards. Whether or not they choose to, I would assume they will. But I don't know. I'm not a part of their brain trust and figuring out how best to go about this. But I don't know what their workload is at the state of California. I don't know where this will be on the priority list, but I assume it will be pretty high. It's no secret. The state of California does not like the way the transportation industry functions. And you hit on it earlier, Brandon. The transportation industry is huge. It is absolutely huge. Yes, there are some bad actors out there. I firmly believe, and I think you believe this as well, Brandon, that drivers should have the right to choose. No one should force them into either bucket. And I believe 98% of the time, that's what happens. But there are some bad actors out there, and I don't feel sorry for them if they get the book thrown at them. The problem is, I think California and some other states assume the whole industry is acting like the 2%.
Yeah. Yeah, I know we were talking earlier, Doug. In my previous life, I did a lot of unemployment tax litigation work on behalf of motor carrier clients and some in California. And through that experience, I got the chance to really talk with a lot of owner operators for our clients and ride along with them and sit with them and understand their lifestyle. And yeah, they were completely of that mindset that if I can't be an independent contractor with my own truck and running the business as I see fit, I don't want to have anything to do with it. That's the lifestyle I want. So when you hear these stories, out there about how oppressed the drivers are through this system of having owner operators and independent contractors, it's just like that's not the world I know. I mean, like you said, maybe there's the 2% or something where it's like that. And again, I feel the same way. I don't feel sorry for them, but that's to apply that same mindset to everyone else is just completely, it's the wrong thing to do for sure.
So the big rig, the USA Today article, and it's unfortunate that, and this is not a railing against journalism in America. There's plenty of great journalists in America, but there was a very, very unfortunate expose, if you will, which told a very sad story. I have no idea how much of it's true for that individual, but I can tell you, even if all true, and how sad that person's individual situation was, that was not an accurate description of what's going on in the trucking industry throughout the United States.
Not at all representative of any of the trucking companies that I work with.
And me either. I can say the same thing for my clients as well. And it's a shame how powerful that article became in some legislators and some agency people's minds.
Brian's asking here, do you expect to see a flood of misclassification lawsuits coming out soon because of this?
I don't know what the threshold for flood will be, but yes, I do expect that I am sure there are some attorneys who probably have been quietly putting together some lawsuits that are now like, okay, I'll just wait for my time to bring some. You also have the state agencies or agency, I should say, chomping at the bit as well. So no, I definitely do expect a material spike in activity in California. Now, again, this is a California thing. It doesn't mean anything else is going to happen anywhere else. But in California, yes, there'll be a big spike.
The thing that's interesting to me, I've been out of the game for a while, so I don't even know how this has played out. But the cases that were started prior to the implementation of or prior to the injunction being issued, have those just been stayed? Have those just been held in abeyance pending resolution of this issue? Or what happened to all those cases?
I'm not involved. I don't have a case that is in that bucket, but that's my presumption. Maybe that some went away via settlements and stuff like that. But yes, that would be my presumption.
So now,
that they would all
not only do you have the possibility of all new lawsuits, you have the possibility of the reinstatement of lawsuits that have been pending for several years now, waiting on the Supreme Court's ruling on this. So
Yes.
it could be a huge issue. And then, you'd brought up also state agency potential enforcement of this. So, and I think we got onto another topic before we finished, the how wide-ranging the AB5 is going to be. We talked about it coming into play in the wage and hour context. Is it your understanding that it's also now, the ABC test is now also going to be used in some of the state actions? You had mentioned potentially not workers' comp, but unemployment. Do we have any idea whether that's going to be the test for unemployment? I think traditionally it had been the Borrello test. So I just don't know. I haven't tracked it close enough.
It is and it's a great question. I think it is just wage and hour. It is not a unemployment, work comp, Department of California Department of Revenue rule. That being said, regardless of what the rule is, we know what the attitude is in California. Even before AB5, there was already a stories, and I'll just call them stories because I didn't handle any of them, but there were stories of how aggressive California was being pre-AB5 on enforcement, and that they really weren't even listening to what the carriers had to say.
I'll take it the next step. Not stories to me, because I was involved, and they were very aggressive. I mean, we would have carriers with thousands of independent contractor drivers, owner-operators in California, and they would just go after them so aggressively, flying in the face of the legal precedent that was in place in California and the tests that were supposed to be used. So, yeah, it's so like you said, even if it turns out that the ABC test is now not applicable, not necessarily applicable in those other contexts, those are still other huge areas of exposures to carriers with owner-operated fleets in California, needless to say.
That's exactly right.
Okay, so let's see. We've got a couple other questions here, and I think this is the big one that everyone's here to get the answer to. So what will this mean for 1090 independent contractors, if anything? Will they need to be changed over to W-2, essentially employees? So I guess the question is, what are the options for motor carriers that have owner-operated fleets in California?
So a handful of things. So the first thing is this was part of your question there towards the end, is you have to determine how much of this rule applies to you. So if you are a trucking company headquartered in California, this very much applies to you and just about everything that you do. Do you have terminals in California? Do you have no physical facilities in California? Do you have dedicated runs, or just have people that go in and out? Are they different people that go in and out, or is it the same Joe and Susie going in and out every day? You have to figure out how much exposure you have in California, because one of your solutions might be, 99% of our business is outside of California. We can deal without the 1%. That might be your answer. We're just going to do things a little bit differently. So first of all, take a look at yourself operationally in your business and what's going on and how much this applies to you. The second thing is, if you do say this does apply to either all or a portion of my business, I'm not going to say it's easy by any stretch what you can do. And I'm not here to tell a carrier, hey, here is the model. Do this, you're going to be fine. We all know it's a case by case, and you got to talk about people's individual situations. There are a handful of ideas out there. The most prominent and likely the most realistic is the broker carrier model. So you, trucking company, stop being a trucking company. You start being a broker. And if you're going to do that, and the next step of that is then the independent contractor becomes a carrier. The independent contractor goes and gets DOT authority, and they do all the things that you teach carriers how to do in the safety and the regulatory world and all that kind of stuff. That they have to take on all that on.
And the idea, right? The idea, right, with that is that gets you around that B prong potentially, in that they are now, your argument would be, they are now clearly in a different line of business than us. We are a broker whose business is to tender freight to motor carriers. They are a licensed motor carrier in their own right. That's the argument, essentially.
That is the argument. And people just have to understand that's not just a little bit of paperwork changes. If you're going to do that model, it's a good model. I like the model, and it works. But you got to kind of go all in. It's going to change the way you do your customer contracts. It's going to change how your insurance works. It's going to change your equipment, obviously, because it's not going to be your equipment anymore. You're not going to have anything to do with the equipment.
And it's going to be a big burden on those owner operators because they're going to have to go get motor carrier authority. Now they're subject to all of the safety regulations that you have traditionally been handling, driver qualification, hours of service. That is now their burden to worry about.
Yes, and I think when you use the word burden, it's a great word, because let's say that you're a carrier today using independent contractors in California, and you've got a shipper that requires $5 million in auto liability insurance. Okay, so if you're going to do the broker carrier model, then you need to make sure all of those independent contractors have $5 million of auto liability insurance.
Tough.
And that's going to be tough. That's a burden. And I don't having any issues with insurance companies, but I can see insurance companies going, wait a minute, you want me to give a whole bunch of $5 million auto liability policies to all these folks with one truck, and I don't have the history and I don't have the safety practices that I knew that you had as a carrier and all that kind of stuff? That's a tough ask of insurance companies.
I think that's the biggest hang up to this model, right? Is the feasibility of getting the traditional owner operators to be motor carriers in their own right, particularly on the insurance front. From my experience, getting them even $750,000, which is the minimum insurance, with no history of operating on their own, et cetera, is a tall task.
Yep. So maybe I might answer this question that way. That is probably the most tested new model. I'm not going to use the word solution. I'm not going to use the word workaround. I don't like those terminology. To me, that suggests you're trying to get away with something. That's not what we're here to do. But if you believe in wanting to use independent contractors because of how good they are and what they can do for you and your business, then the broker carrier model, and there are some other variations too, but that's realistically what we're looking at. Or they become employees.
We had one question on that. One question on that broker carrier model, real quick. Somebody's asking. We use settlement carriers in CA, which are essentially it's the broker carrier model. We have a broker carrier agreement with them. Several of these are single truck carriers. Any risk to us in that scenario?
First of all, you're right. Settlement carrier is another way to call the same thing. Yes, there can be risks. There is history in California pre AB5 of California accusing brokers, just the traditional broker model, of being either employers or joint employers of the drivers that the carriers used. So there's already precedent that California might still go after brokers in the broker carrier model. Second thing is your risk increases with how much you don't do the broker carrier model right. And that goes back to this. If you're going to do it, then you got to do it right. And that's a different type of contract with your customers. It's a different type of contract with the carriers. It's a different type of equipment model and financial model and all that kind of stuff. It can't be just a different contract.
Yeah, and even so, what I saw so frequently with carriers who were hot to trot on this new model, they didn't even take the effort to change their contracts. So their contracts are still calling them the motor carrier. It's like, yeah, this very clearly is, you're trying to make this just a paper change. It's not a paper change.
Correct.
Yeah.
Correct. Yeah.
So sorry, I kind of cut you off there. So putting aside the broker carrier model, so the other option is converting to employees if you want to still do business. I know several carriers who said the risk is too high, we're getting out of California altogether. Folks will tell you that's not happening, but it is happening. I know a lot of carriers that have done that already. So assuming you want to stay in California for the reason you mentioned, Doug, which is a huge part of the economy, transitioning to employee drivers, at least for your portion of your fleet in California, right? So this isn't necessarily saying you have to change your entire fleet. If you've got operations nationwide, maybe you consider some kind of, compartmentalizing this and setting up a new entity where you do business differently in California than you do elsewhere in the country. I think that's an option as well.
Yes, that's an option. There are also carriers out there that do more of I don't really know what the right phrasing would be to use this, but when you start, and this actually is less to do with the ABC test and more to do with a different test called the economic realities test. But when you can say that the contractors can buy and sell routes, that is a very meaningful factor in saying that someone is an independent contractor. Now, they're not in those examples. Those independent contractors are not buying and selling them for $100.
Yeah.
They're buying and selling them for real money.
I think we would always kind of call it like an agent model or something like that, where the
Yes.
owner operator is an agent of the carrier and is essentially a sales agent at that point.
Yes. Yep. That's one way to describe it as well. So broker carrier or settlement carrier is not the only one in California. It's probably the most common that we're seeing so far, but there are other variations. I don't want anybody to think this is an automatic death knell to independent contractors in California. It is significant. It requires very thoughtful analysis of what to do next. And it likely requires some pretty fundamental changes to how you're going to do business, no matter which path you take. So get your trusted advisors around, your lawyers, your numbers people, your operations people, your sales people, because it's going to impact all of it.
Because even if you take the position that, okay, I'll just transform them all to W-2 to employee drivers, there's a lot that goes into that too. So it's not like that's going to be an easy change, because I just think of like, these drivers all own their trucks. They're owner operators. Employees don't provide their own trucks. So now you got to come up with a solution for dealing with the trucks, whether it be some kind of reimbursement or that 2-check system that we've heard about in the past. It's like, you got to think through these. There's going to be a lot that goes into it.
It's funny when I hear 2-check start coming up, because there's got to be a whole bunch of people that are retired from the industry that are sitting there going, holy smokes, you people think you're going to do the 2-check system again? It's been a long time since the 2-check system has been relatively common or prominent. And just a quick version of what the 2-check system is, really what you're doing is you're saying, hey, instead of paying you, making up a rate, instead of paying you contractor $1.20 a mile, I'm going to pay you 40 cents a mile to drive, and I'm going to pay you 80 cents a mile to lease your truck from you. So that the truck lease payment it's a lease payment. It's not there's no W-2 wages and taxes and everything that get deducted, but you driver are an employee, and I'm going to deduct taxes and give you benefits and all that kind of stuff. That's the 2-check system.
And it makes,
administratively, it's a burden.
It's a burden, but it makes sense, because the thing that we were always battling on at least on the unemployment side, was the state would come in, reclassify all of the drivers, all the owner operators, and then consider all of their payments to be wages and tax you based on what you paid to them. But that's not a wage. Clearly, a huge portion of that is meant to compensate them for the use of their truck. I think the numbers were always like 2/3 of that payment is for the truck, and only 1/3 could really be considered akin to a wage. So by kind of doing the 2-check system, you're kind of trying to limit your exposure to just what would be considered a reasonable wage for their actual service. And then you're not being taxed or have other exposure on kind of that truck payment, as I understand it.
The 2-check system philosophically makes a lot of sense, and I think it can work. When I've seen it in action, people get confused by it. It's administratively very difficult. I've seen tax people on the government IRS, Department of Revenue side go, "What the heck are you doing?" and have problems with it. And I've seen companies get in trouble on the tax side with it. So it's not a golden solution it's not a silver bullet. But I'm curious if there are trucking companies that go down the 2-check path.
So I think, long story short, you said it best, Doug. It's not a solution that you should take. It's not something you should take lightly. You need to talk with your tax advisors. You need to talk with your lawyers. Figure out a solution that works best for you before you pull the trigger on any one solution.
That's exactly right.
Let's see here. We're running out of time. Let's see. Brian's got one other question here. I think it's a good one. What states fall next? Do you have any thoughts on that, Doug?
So, I mean, we can guess and speculate. What I will, and we'll throw some out here in a minute. But when we think about the politics of this, this is my plug for get engaged. Engage with your trade associations at the state level, at the federal level. and really what it's about is telling the story of the real people that are impacted by this. We need we need to share the story of the independent contractors that enjoy being independent, the independent contractors that grow their business and so forth. So I would encourage you, first of all, to get engaged on the issue at the political level, both at the state and the feds. What states go next? It's not necessarily just blue and red. This is not 100% a blue and red thing. Yeah, it's kind of a blue and red thing, but there's some red states that are not good on independent contractor status, and there are some blue states that are very good on independent contractor status. So don't immediately go there. Where you just keep your eyes and ears open, because sometimes it surprises where it pops up next.
Yeah.
I think that's really all I can say here, other than going down through a laundry list of all 50 states. But,
Yeah.
but that's, I think, is the best advice.
Yeah, and I think we're at the end of the line, at least in California, in terms of judicial solutions to this. And so really the only solution, if enough people decide that they want to change the way that this is, then the solution is through legislation. And that's the only way anything's going to get changed.
I agree, but I'm not a complete expert in the litigation currently. But it is my understanding is the Ninth Circuit's decision essentially just says this goes back to trial.
To the trial court.
So
to litigate on the
California
facts of the
Trucking
case.
Association- Yeah, the California Trucking Association could still litigate this. They've already spent millions of dollars. How many more millions they're going to spend on this, I don't know. Because if I can, and I know some of the CTA folks, and they're good people, and part of them is going to be going, how much longer are we going to foot the bill for everyone else in the country?
Yeah. Because, just kind of thinking through that, I mean, really, in my view, the only thing they could be arguing at that point is the facts of that case. So the contractors that are before us in this particular case, they pass the B prong. And so I think, in my view, at least, the writing's on the wall on that B prong. But, this is not putting an end to litigation that you'll still be able, you still have the option to bring, a case to challenge that they meet the meet the ABC test, but the chances of success on a substantive, trying to argue that substantively, I think are pretty low.
I agree with you. I don't want to say that, give the people there's these grand hope. It is my understanding is that it can go back to trial.
Yeah.
And what the CTA then would be trying to do is actually to prove that you cannot meet the B prong or the business to business exemption. Because part of the arguments that the proponents of AB5 were making in their side of all this litigation is this is not the end of independent contractors that you trucking industry claim it to be.
I got you. So there still could be hope for a preemption type argument. It's just we got to get more into the weeds on whether it is impossible to pass this B test in our industry or not.
That is my understanding. I could very well be corrected by some litigation wonks out there, but that is my understanding procedurally what could happen.
I see.
But regardless of that, that's a years-long process, and in the meantime, California can enforce. So if I'm a trucking company, I'm probably not willing to just take my chances. And
roll the
hope,
dice.
Yeah, that the litigation turns my way over time.
All right. Well, you heard it here. Thanks, Doug. Really appreciate you joining me. Obviously, a huge topic for a lot of both of our clients and carriers all over the country. So we'll keep a close eye on it, and really appreciate you joining me today.
You're welcome. Thanks for having me, Brandon.
Hey, real quick before you leave, tell everybody where they can find you if they have any questions or anything like that.
Yeah, www.thegrawegroup.com. We do a lot of work with independent contractor programs and just helping trucking companies however we can. So we got a team of people who used to be in the chair, former C-suite execs from a variety of trucking companies, and that's what we do to help.
Awesome. Thanks, Doug. All right, so we're going to wrap it up there. Before we do, I just want to kind of give you a quick look at what's going on here at Trucksafe. We've got a ton of stuff going on. First and foremost, August 11th and 12th, we've got our first annual Trucksafe Fleet Compliance Summit. Doug's going to be one of the speakers joining us. We've got about 21 speakers booked for this to talk about all kinds of issues that are impacting motor carriers and practical tips to try and reduce exposure in those various areas. Things like nuclear verdicts, independent contractor status, fleet technology, insurance, cargo claims, all of that type of stuff. It's going to be a 2-day multi-session event. It's a virtual conference. Come for one or all 8 of the sessions that we're going to have with our various speakers, and then also we're going to have a pretty cool virtual event or a virtual expo hall where we've got dozens of vendors, industry vendors that are going to be there setting up virtual booths for you to check out the latest and greatest products and services available to trucking companies, speak with representatives, check out screenshots and materials on their services and products. So check that out, trucksafesummit.com if you're interested. Registration is open. Again, that's August 11th and 12th. Next up is our library of online courses that we have available at trucksafeacademy.com. If you have any interest in getting more up to speed on DOT safety regulations, we've got courses built specifically for safety managers, anybody in a position of managing a regulated driver, whether it be a small trucking company owner or safety directors, dispatchers, those types of folks. We've got courses built specifically for them where we focus on the DOT safety regulations and walking them through them and exactly what they need to know. We've also just recently launched a hazmat course for folks that are involved in the transportation of hazmat. Check those out, trucksafeacademy.com. And then lastly, be sure to tune in for our next TruckSafe Live show. Again, this is a monthly show. This was a special episode, but our regularly scheduled episode is coming up on July 21st at 3 p.m. Eastern Time. It's called The Doc Is In. We're going to have with us Dr. Mark Manera and Dr. Matthew Nuez, who are very heavily involved in driver health and fitness issues. And so we're going to spend some time talking with them and kind of best practices for driver health and fitness and what we're seeing kind of in that area. So tune in, again, July 21st at 3 p.m. Eastern Time. With that, we're going to wrap it up. Appreciate y'all joining us, and we'll see you soon.